Welcome back, everyone. Our first speaker today is Mr. Brad WANG, the Deputy Secretary General of CATEC Hong Kong Arbitration Center, the first overseas branch of CATEC, which is the largest and oldest permanent arbitral institution in China. He supervises CATEC Hong Kong's case management team on administering arbitration cases and scrutinizes 300 draft arbitral award on a yearly basis, primarily on financial, shareholder, and construction disputes. Before joining CATEC Hong Kong, our speaker was a litigation lawyer in a well-known Chinese mainland firm and also advocated in cross-border arbitration cases, mainly seated in Beijing, Shanghai, and Hong Kong. His topic is policy and regulation of mediation in the mainland, insights for the future development of mediation practices in the Greater Bay Area. Mr. Wang, the stage is yours. There will be a question and answer sessions after our speaker's presentation. For online audience, please type in your questions in the chat box. For on-site attendees, please scan the QR code and type in your questions. Thank you.
唔好意思，因為琴晚啦，我做一個 test run 係用廣東話做呢個 presentation，有同我粵語老師，佢就話啦，其實你都可以等多陣再試下用廣東話講，所以呢，我今年就用翻 English，但下一年啦，如果有機會可以用廣東話，我覺得等多陣一年就係應該 contest 多陣。Thank you so much. So today I'm going to talk about, it's actually a very big topic. It's about policy and regulation of mediation in the mainland, which is about insights for the future development of mediation practices in GBA. It's quite a big topic, and to be honest, I fell asleep several times during preparation of this presentation. So I deleted all the parts that led me to sleep. So I will more focus on basically what everyone cares, what those policies or those types of mediation mean to practitioners here in Hong Kong and students in Hong Kong, and what can you do in those kind of mediations in the future in Chinese mainland. And I'll speak very slow because I understand there will be translators. Quick introduction about our arbitration institution. As dear moderator has just mentioned, I come from the oldest and the largest arbitration center headquartered in Beijing. It was established in 1954. At that time, in People's Republic of China, there was no arbitration institution. So when Chinese businessmen were doing business with foreigners, the foreigners in their contract would propose, or draft contract would propose an arbitration agreement and stating maybe let's have an arbitration if dispute arise, for example, in London Court of International Arbitration. So the Chinese businessmen look at the draft contract and would consider, do we have an arbitration center in Chinese mainland? And at that time, there was no. So under that situation, Chinese government had a direction to order an establishment of an arbitration center in Chinese mainland under the China Council for the Promotion of International Trade. So at that time, the first Chinese arbitration center was established. So you may get a sense that the contemporary Chinese arbitration is sort of an imported product because we learned from the outside world that there are arbitration institutions, commercial arbitration doing outside of Chinese mainland, and we want to do that. But at that time, we didn't have the corresponding laws and regulations to deal with actual arbitration cases in Chinese mainland. So a lot of arbitration cases, when they were sent to us, were resolved in mediation. So that's why CATEC developed a heavy appetite for mediation to start with. So that's the history and how we were established and what's our connection with mediation. So almost 70 years later, we became one of the largest arbitration institutions in the world in terms of case number, dispute amount, and number of nationalities of parties. We had roughly about 6,000 cases last year. And to make it relevant to today's topic, about 15% of the cases that we have in arbitration were finally resolved in the form of mediation. So we still have roughly about 1,000 cases that reached us in the form of an arbitration application and ended in the form of a mediation settlement with the help of mediators or arbitrators/mediators. That's the advertisement part, so that's done. Okay, today I want to start with an illustration or explanation about what are happening in terms of mediation in contemporary China or Chinese mainland. To make it easier for you to understand, I know some of you are students and look so promising and young, and so I'll try to explain them in a sense that it's easier for you to understand. It's not technically correct explanation, but I think it basically gets you there. I'll start with people's mediation. People's mediation is like the earliest form of mediation in China. It went all the way back to before the People's Republic of China. I think it was already taking place in the controlled areas of the Communist Party of China. In Chinese, we say 解放区. So that's before PRC was even established. It was already used. So it was actually, as a matter of fact, people's mediation that was considered the Oriental experience, as you would learn from the academic books that may get you into sleep. People's mediation, let me give you an example. What we do here in Hong Kong that is like people's mediation. So last week, as I was in a gym, start with letter P. So in that gym, I walked into the gym and I found my friend was lecturing, giving a lecture to another people working out in the gym because he thinks he's blocking the way and very rude. So the lecture turned into an argument. An argument turned into a threat to fight each other. So in that gym, the gym staff called the police officer. And police officer, I think 5 police officers arrived. And they were separated to 2 teams. One team of 2 and another team of 1. So 2 were discussing this issue with one of the people in the fight. And another 1 person was talking to my friend. So basically asked them what happened and what do you want from this fight? Or how do you want to resolve this? Do you want to file charges? If you don't want to file charges, let's reach a settlement and send each other an apology by email. And both of the people who were in the fight decided they don't want to press charges or being pressed charges. So they settled the dispute and shake hands with each other, send an apology on the via email, and promise to the police officers they are not going to press charges. And the police officers also tell each other, next time you run into each other in the gym, try to stay away from each other. So that's the whole solution. So the police officers in this sense, sort of act like one of the very basic form of mediator, people's mediator in Chinese mainland, because they are not titled mediator, they are police officer. They have their own occupation. But in their everyday job, they need to resolve some disputes in people's everyday life in this situation. So it is like that in Chinese mainland, people's mediation has developed so fast, so rapid. As a matter of fact, I'll briefly switch to the next slide because people's mediation, I want to emphasize 2 things. How common it is. It is roughly calculated that in Chinese mainland, there are more than 700,000 people's mediation offices containing 3.2 million people's mediators. And among which full-time mediators, people's mediators, 0.3 million people's mediator. And they resolve every year 9 million cases, 9 million cases. And I just use that pure, no, I just mentioned the name of the gym, the gym's fight as the how police officers resolve that. That's considered one case. And those police officers is like the not full-time people's mediator, non-full-time, because they have their original job. So that is sort of like people's mediation in Chinese mainland. How do you resolve, what are the most common types of disputes that are resolving people's mediation in Chinese mainland? One example could be the medical treatment related conduct disputes. So it could be between doctors and the patients. It could be the patients between the hospital, so they may have disputes. And the hospital or the hospital-related association could set up people's mediation office to resolve those disputes in their own association rather than in the courts or in arbitration hearing centers. So that's people's mediation. What are the features? That might keep some mediators away, because one of the features of people's mediation is that it's free of charge. They won't charge anything from the disputants. Just like my friend and the guy he was arguing, they won't charge. They won't charge anything. Okay, they were resolved by the police officer. Didn't pay anything. Okay, but that doesn't mean the police officer didn't get paid. They get paid by the police department, right? So it's part of the whole package. But if you are a full-time people's mediator, those associations, those offices will still pay you. So it's free of charge for parties, which is quite a good feature for the disputants in that. And another significant feature is that any settlement reached in Chinese mainland in people's mediation are not directly enforceable before people's court. You need to have a special procedure called court's confirmation, 司法确认, 司法确认. So in that, after that procedure, you can enforce the mediation settlement. Why is that? Because people may make fraudulent settlement because there are so many people. Remember, almost 3.2 million mediators, and I'm sure not all of them have taken any mediation or courses, trainings, right? So it might have discrepancy in the standard of helping parties to reach mediation settlement. So the court needs to take a look at this to see if the mediation agreement is genuine or there is no agreement that's against the law. For example, they can't use people's mediation to make a divorce. Right? If the content of people's mediation agreement is about divorce itself, it's not valid. So it won't be confirmed by the people's court in Chinese mainland. Coming back to administrative mediation, that's like the second type of mediation in Chinese mainland. It is commonly used in the labor-related disputes between employers and employees. In Hong Kong, we have similar situation where if you are employee and you look for, say, a small amount of wage, which is, for example, 5,000, 3,000, you go to the 劳工局, is that correct? Is that correct pronunciation? 劳工局, you file a claim and they will help you. The feature of administrative mediation in Chinese mainland, especially labor disputes in administrative mediation, is that it is quite hangzheng feature. It's not the whole thing is part of the administration process. Why is that? Because when I was a student, and when I was studying labor law in Chinese mainland, I was taught that the the coordination of the relationship between employer and employee is something larger than an individual matter. It has something to do with the macroeconomy development of the whole country. So it's more of a public feature than a civil feature. So the government took the lead to resolve the disputes between employers and employees. Sometimes, for example, if they want to boost the economy, they might have a stronger link on the employer's right rather than the employee's right. However, if economy is there and they want everyone to live a happier life, they might be more leaning towards the employees than the employers. So with macro regulation or balancing exercise, they put the right to do the labor and labor disputes in the public organization. So this is more of a public sector mediation. So mediators are not everyday mediators like people's mediation or in the arbitration where arbitrators serve as mediators. Another key feature in the administrative mediation is that, for example, in labor disputes, you can directly enforce that settlement agreement before people's court according to labor dispute mediation and arbitration law enacted in 2007. I'll talk about MEDAP later because that's something I want to put more time on. But I'll go to the fourth one, judicial mediation. So that's usually defined as judges taking a role in helping parties to reach a settlement agreement at any stage in the court process. But I want to deviate from judicial mediation and go back to people's mediation in the context where people would like to file a lawsuit in the people's court. Why is that? Because that might be relevant for those of you who are sitting here who want to act as a mediator in Chinese mainland. Now, because people's court at the moment in Chinese mainland have roughly just so many cases, if judges are stretched too thin. They just can't handle that many cases each individually. What they are trying to do is that before the court procedure actually starts, they ask the parties, they ask the claimant willingness to start a mediation. Now, that kind of mediation can, of course, be conducted by a judge. A judge can also wear a hat of a mediator and mediate the cases for the parties. It's like, say, when I was really young, when my parents was going through a divorce cases, there is a mandatory mediation process that's conducted by the judge. But now, because there are so many cases and judges, if they started to mediate before the case starts to go through the litigation part, that wouldn't reduce the workload of the judge, him or herself. So the judges themselves now, in certain circumstances and in certain areas in Chinese mainland, they get to authorize and employ third-party mediators or mediation organizations to do under the title people's mediation to the parties. And if they reach a settlement, that case is resolved in people's mediation. And at a later stage, the court proceedings can do the judicial confirmation to realize, to enforce the settlement. So a lot of people with expertise, like in engineering, can be involved in this people's mediation process before the court litigation cases. Am I making myself clear? So it's not part of the judicial mediation because technically judicial mediation are conducted by judges. But judges now, they are now just let go of some of their workload and employ some of the third-party mediators to help them resolve the disputes before they even reach to the court to hear. So that's the thing that's relevant. Also, if anything, any settlement let's go back to judicial mediation, where judges now, they are also mediators at any stage in the court litigation process and help parties to reach a settlement. If parties reach a settlement and they either end in the form of a conciliation settlement or they withdraw the case, there are financial incentives for them to do so because the court will reduce the court fee for the parties. So it actually encourages, in this way, parties to withdraw the case or to reach a settlement. And what does that bring benefit to the judges? Well, if the case is ended in settlement agreement rather than judgment, those decisions are much less likely to be appealed or successfully appealed. So if you treat the judges as a student, if you, at the end of your semester, you want your record to say, oh, we have 0 cases that's been appealed, right? It looks good on you. So both from the judges' end and from the disputants' end, they have incentives to use judicial mediation and reach a settlement agreement in the process of judicial mediation. Last but not least, is the commercial mediation that's quite relevant to everyone's work here in Hong Kong. Now, when people talk about mediation in Hong Kong, especially those who are already involved in the mediation industry in Hong Kong, you think about the mediation in the form of commercial mediation, where you have a third-party mediator who are not involved in the concurrent arbitration case at all, appointed by the parties, have your own mediation rules, and if successful, help parties to reach a settlement agreement. In Chinese mainland, it was firstly developed in what we call China Council for the Promotion of International Trade. We have had the first mediation center in Chinese mainland under CCPIT. So CTAC was also established in CCPIT, so it's the same organization. What's CCPIT like? I'll give you another not very accurate comparison or example. It's like Hong Kong TTC. Hong Kong 冇法律. Okay, it's like that. So it's like the Chinese mainland 冇法律, it's like Chinese mainland's counterpart, but not technically right, but just give you a rough example. So it helps to boost the economy and enhance cooperation between business sectors, CCPIT. Now, in Chinese mainland, the first mediation center was established in CCPIT. And that mediation center can carry out mediations proceedings by themselves. What if they reach a settlement agreement? Well, they can give them to CTAC for an arbitration award at the end of the day, or they can end in the form of settlement agreement, or they can go directly enforce it in the Chinese mainland court. So that's CCPIT. At CTAC, we also have established our own mediation center. That mediation center has its own mediation rules, has its separate panel of mediators, and mediators are paid at a market rate. So it's not like MEDA where mediator/arbitrator get paid in one dose in the name of arbitrator. So at CTAC, if you mediate a case in our mediation center, as a mediator, you will get paid separately. And if you decided to have an arbitration later after the mediation process, because CTAC also has arbitration rules, we can have a bridging exercise to make the whole mediation and arbitration cheaper than if you have it mediation and arbitration at 2 separate places. I believe the Deputy SJ has mentioned the third bullet point, which is about the decision by the Guangdong Provincial CPC. It has something to do with open more mediation centers, like the centers I have just mentioned before. And mediation centers need mediators to mediate. So that's the simple logic behind. So that means more opportunities for mediators in Hong Kong to practice in the Greater Bay Area. Now, for commercial mediation, if you have studied mediation, know the bolts and nuts about mediation, that kind of concept is more leaning to facilitative rather than evaluative. Because why is that? Because that mediator do not need to take the role as judicial mediation, which he or she will at a later stage become the judge, or met up where that mediator will also be the arbitrator. So he or she, at the end of the day, if he or she is sitting in the arbitration or in the litigation, will get to determine the case. So he or she distinctively or just subconsciously will provide some opinion that has something to do with evaluation. Some, for example, the court judges who serve as mediators sometimes will ask parties, do you think that that is just your submission? Do you think there will be risks if the court decides otherwise? So that's quite a strong and evaluative opinion that some parties may take in. So in commercial mediation, where mediator's role is solely on mediate, and he or she will not wearing any other hats, it's more leaning towards facilitative style of mediation, where most of the people who are under mediation training in Hong Kong would be very familiar. Now, let's go back to the last type of mediation. I think I have 15 more minutes, right? Okay, I'll talk about the last part of the types of mediation, which is called met up. So it's more of a combination of mediation in the process of arbitration. Why is that relevant? I think if you haven't done any mediation, but you are already in an industry that is quite heavily using arbitration process, this type of met up will get you a first and direct experience of mediation. So it's like people always say, the most difficult step is from step 0 to step 1, right? That's like the first step is the it's a milestone event. Now, if you are an engineer that is being appointed as a co-arbitrator in an arbitration process at CTAC, when parties decided to submit to the tribunal, we are actually, both of our parties are willing to mediate before your distinguished panel of arbitrators. The presiding arbitrator may ask you, do you agree or disagree? Well, most likely you won't say disagree because you have never done a mediation case. Because you know your role is a co-arbitrator, more than likely you will take it, because you know the presiding arbitrator will primarily take the role in the process of mediation. He or she will take the lead, so you will accept it. Then you get to observe mediation process being practiced in real life. It's usually done after the oral hearing. Usually you have, at that stage, already understand what is happening in the case. So you will already have a very good understanding of the case, and you will experience what mediation is being done. Now, it's called met up, mediation being in the process of the arbitration. It doesn't mean that any necessary procedures in the mediation are missing if that mediation process takes place in arbitration. So every standard or necessary procedures are explained and illustrated to the parties. Your rights, what you should do, what you should not do, are included in the met up process mediation. So I think that would serve as a very good practical experience. So if you are, in the future, if you are sitting as a CTAC arbitrator or any other institution, we have arbitration representative from Shenzhen who will deliver a wonderful speech this afternoon, do so and get some experience. And then if it's a separate mediation process in the future, it wouldn't change a lot regarding the essence of what you should do and what you should not do in the mediation process. So I think that's a very good start if you want to have the first-hand experience, real-hand experience about mediation. Now, the next part is a bit technical because but it's very useful. So, but I'll try to make myself easily understood. So, how do you do mediation process in the CTAC arbitration proceedings? You need to look at our arbitration rules. Our arbitration rules has the longest article in its rules, and it is called combination of conciliation with arbitration. So conciliation, mediation is interchangeable in global context. Starting with Article 47, it says where both parties, so disputants, wish to conciliate, or where one party wishes to conciliate and the other party's consent has been obtained by the arbitral tribunal, the arbitral tribunal may conciliate the dispute during the arbitration proceedings, and the parties may also set their dispute by themselves. This is the first article in the arbitration rules that tells us how to initiate mediation. So it can happen at any stage, but it requires parties' consent. We can't force you to mediate. Why we make that very clear in the arbitration rules? Because in certain time, like say a decade or 2 decades ago, there was an idea or school of opinion that in Chinese arbitration institutions, if you face difficult or important cases, there would be some internal conduct to force parties to do mediation in order, rather than to carry out the standard procedure of arbitration. So we made it very clear in our arbitration rules that that's not going to happen. You need both parties' consent to do mediation. And put it into Hong Kong context, and I want to bring out the next point. That's regarding arbitrators who will have to work as mediators in our cases. You also need arbitrators' agreement to start the mediation in the process of CTAC arbitration. Because I understand in common law jurisdictions like Hong Kong or London, there are arbitrators who would feel very uncomfortable also serving as a mediator in the proceeding of arbitration case. So we use the term, the tribunal may conciliate. So it's not necessary. We have real cases in Hong Kong where the barrister say, no, I don't do the mediation part. Partly it's also because we pay the barrister a package deal. So if you do extra mediation work, no extra payment. But just an example is no, it's not like talking short of barrister or anything. Just happen to be an example. Now we also have common law lawyers that are willing to do mediation in the CTAC context, also serving as arbitrator, and ended quite successfully. But it's up to parties' consent and the tribunal's own willingness. So that's what we have to say. And the last sentence is quite helpful for the third-party individual mediators, as many of you are sitting here. It says the parties may also settle their disputes by themselves. What does it mean? That's the room for commercial mediation. So we can have the ongoing arbitration keep going, and you can start your mediation elsewhere. It's fine. You can settle your disputes by yourselves, with or without the engagement of the arbitrators in the arbitration process or mediators outside the arbitration room. So it's totally up to parties. All the selections are viable. All the choices are viable. Second paragraph, it says, with the consent of both parties, arbitral tribunal may conciliate the case in a manner it considers appropriate. Now there comes to the good old and long argument about which one is better, facilitative or evaluative. So now arbitrators, with the consent of parties, will conduct mediation in the CTAC arbitration process in a manner they consider appropriate. So it could be facilitative, it could be evaluative. As a matter of fact, in CTAC Hong Kong, where we sit in a common law jurisdiction, we both seek facilitative and evaluative mediation being done at our hearing rooms. And when does it happen? It could happen anytime during the arbitration process. But usually, we find that tribunal feel more comfortable having heard the case. I mean, after the hearing is finished, they will have an immediate subsequent mediation process. Because after the exchange of ideas at the hearings, parties know their position better because they hear what the other party has to say at the same time. So it helps parties to get themselves a reality check. That term is often used in mediation. So at the end of the day, remember, this is a consent by parties and tribunal in terms of the way they want to do the mediation. They feel comfortable because it takes only one party to terminate the whole mediation thing. Either it's from one party or from the tribunal itself. Paragraph 3, it says, during the process of mediation, the arbitral tribunal shall terminate the conciliation proceedings if either party so requests, or if the arbitral tribunal considers that further conciliation efforts will be futile. That's exactly what I've just said. It only takes one party or from the tribunal to terminate this. We can't. It's never allowed to use mediation to delay the proceeding. If one party say, I'm out, this is out. Arbitration resumes, and we have a deadline for the arbitrators/mediators to finish the arbitral award within prescribed time. Paragraph 4, it says the parties shall sign a settlement agreement where they have reached the settlement through conciliation by arbitral tribunal or by themselves. Paragraph 5 says, where the parties have reached a settlement agreement through mediation by the arbitral tribunal or by themselves, they may withdraw their claim or counterclaim or request the arbitral tribunal to render an award or a conciliation statement in accordance with the terms of settlement agreement. So there are 3 options to leave this arbitration. First way, after they reach settlement agreement and parties are very confident that there will be voluntary enforcement at a later stage by the other party, the party can withdraw the case. Why do you want to withdraw the case? 2 most likely reasons. Number 1, it has financial benefit because if you withdraw the case, we refund you. We give back some of the money you paid to the arbitration center. And that can be significant if the dispute amount is very high. Second reason, a lot of state-owned enterprises and a lot of very high-stake companies, they have their own KPI about how many cases they have in a report year, okay, in a work calendar year. If the case is withdrawn, it shall be deemed as no arbitration was filed to start with. So that reduces the number of the cases. So in arbitration institutions, we take pride in how many cases we have, but in companies, they take pride in how few arbitration cases they have. If they withdraw, that case doesn't count anymore. Now, that's the first option. You can withdraw the case. The second option is that you ask the arbitral tribunal, who also serve as mediators, to give you a consent award. Those who studied mediation know that words. This is basically, they record the terms in the mediation settlement and finish it in the form of an arbitral award. Why do they want that? Primarily, an arbitral award will be effective the day the arbitral award is issued. So once the parties submit their settlement agreement with their signatures, arbitral tribunal can quickly turn it into a very efficiently enforceable arbitral award. And that arbitral award can be enforced at a different jurisdiction. Say if that arbitral award is made in Hong Kong, you can enforce this in Singapore. But if you only have had a settlement agreement and you withdraw the case, that settlement agreement is binding only on parties themselves and may not be directly enforceable in another jurisdiction. So you want an arbitral award. Now, you can also choose the third option, which is not to ask the tribunal not to finish this case in the form of an arbitral award, but in a conciliation statement or mediation statement. What is that? 廣東話叫調解書、調解書、書、一棵書、一本書、調解書, mediation statement. Why do we want that? In Chinese mainland, a conciliation statement or 調解書 is to the same legal effect as an arbitral award. So enforcement related issue won't be a problem in Chinese mainland. But because if you want to finish it, the case in arbitration award, the arbitrators need to be very careful regarding the scope of arbitration, because parties may agree more than what they have had bring the case to the arbitration court. For example, I have 3 more minutes. I've been too slow today, sorry. Let me go back. Say if I'm a buyer and there's a seller, so we bring one case to the arbitration court, but we have more than one transaction than this buying and selling. We might actually use the mediation to settle more disputes between us. If it's finished in the form of arbitration award, the tribunal needs to think, oh, what about the other disputes? Do they have the same arbitration agreement? Do I have jurisdiction? That's something they need to consider when they finish the case in the form of arbitral award. But in conciliation statement, at the end of the day, it's like a more relaxed form of decision than arbitral award. So tribunal can slightly ignore that kind of, let me rephrase, can be more relaxed when it comes to jurisdictional related matters. So conciliation statement. But conciliation statement has a catch. After the tribunal made the conciliation statement, the parties need to sign the conciliated statement to make it binding, to make it effective. So let's say there's already a settlement agreement parties have signed, and they give that to the tribunal to finish in a form of a conciliation settlement. That conciliation settlement needs to be signed by the parties again to make it effective piece of legal document. So the parties can regret and not sign on the later one. So only effective part would be the original settlement agreement. So it goes back to the previous procedure. So that's why sometimes arbitrators slash mediators they prefer arbitral award over conciliation statement. Okay, actually I can pass all of the below because those are, well, that 2 minutes went very far. Now it's 1 minute. All of those get very technical, and if you're interested, send me an email. I can't just share enough, regarding mediation because I like it. And those get very technical, has something to do with the difference of Hong Kong arbitration ordinance and Chinese mainland arbitration law when it comes to how we deal with certain aspects of mediation in the process of arbitration. But yeah, this is my email. If you have any further question, feel free to write me an email, and I'll be more than delighted to help you. Or easily, I'm on LinkedIn. Just type in Brad WANG, and I'd be ready to answer your questions if possible. And thank you very much for listening. Before I finish, I need 30 seconds to recap. Remember the people's mediation I talked about, especially that part that takes place before the judicial case, the court hearing case. Now judges, they nominate the party to help them to do mediation. That's one thing. And second thing, met up. You can sit in the arbitration process and get to experience the whole thing of mediation. That's the second part. I want you to give that a highlight because those two probably gonna be the first group of cases you meet if you want to deal with Chinese mainland related disputes. So I'll wrap up here, and thank you very much for listening this morning.
Mr. Wang, I think we have time for one question, actually. You won't get off so easily. There's the Q&A code if you, no. Anyway, we have time for one question. The question is, it is great to hear that mediation is being encouraged by judges and legal professionals in mainland China. But are you seeing genuine participation by parties in dispute in mediation process with conclusive settlements as a result and leading to less significant litigation or arbitration? Or are parties participating perhaps out of obligation in the spirit of trying to settle, but it still leads to litigation, arbitration?
There's a quick and short answer, and it's actually quite accurate. In Chinese mainland, yes. In Hong Kong, we hear no a lot.
Thank you.
Yes. And I think the logic behind is the culture and the involvement of lawyers, in short. Because in Chinese mainland, the majority of the cases, if we look at people's court in Chinese mainland, a great majority of cases are litigants in person. They don't have any representation of lawyers. They can't afford lawyers, to be honest, in a lot of cases. It is not economically viable option for them. So if there's a mediation that can save time, save face, keep it private, and resolve it in a very short time, they would do it. They would do it. And not only mediation in the people's court, but people's mediation. It's very, very helpful. But in Hong Kong, I think when I was a student, when I was first studying mediation, I already get the general opinion that they just take that as part of formality to get that certificate. But I think at the end of the day, it's it's a decision-making process. It's very hard to determine which option is right or wrong because you are in different contexts. So, but to answer back to the question, yes, in Chinese mainland, and it seems I've heard a lot of no's in Hong Kong. Thank you.
Thank you.